All right. Well, good evening, everyone. My name is Nicole Cantatori. I am the training director for Worth Ross Management Company, and thank you all for joining us for another speaker series event. I'm going to keep my introduction brief on this topic because it was highly requested. I want to make sure that Greg has every available minute at his disposal to talk on the topic of Texas Uniform Condominium Act, also known as TUCA. So this will be part 2 of this particular topic. So Greg, with that, I will turn it over to you and let you get started with your presentation, and then we'll have Q&A at the end.
All right, thank you, Nicole. As you were saying, my name is Gregory Cagle, and I'm really thrilled to be back here to talk about TUCA. And we'll be examining another couple of provisions of TUCA, kind of extending from where we left off the last time. I'm going to share my screen real quickly, so bear with me for just a second so I can get it pulled up. Okay, so hopefully everybody can see that.
Yes, we can.
So, all right, good. All right, so, oh, hold up just a second. Let's see. All right, there we go. All right, so for those who don't know me, my name is Gregory Cagle, managing partner of Cagle Pugh. Been doing this for a little over 23 years now. Board certified in Property Owners Association law, and author of Texas Homeowners Association law, and a fellow in the National College of Community Association Lawyers. But enough about me. Let's talk about the topic. So, as for those who participated in part 1, we covered sections 82.051, 82.058, and 82.108, 82.112. You can see them listed there. And we also kind of talked about the basics of what a condominium is, and we covered those topics. Today, and if you're kind of doing these out of order, I would highly encourage you to go back and listen to or watch part 1. I think it'll really help you in understanding what a condominium is, so that these other provisions will make a little bit more sense. But tonight we're going to cover section 82.114 and 1141, which are sort of linked. And this is really about association records and production of those records and owners or unit owners' rights to inspect them. Then we're going to talk about the provisions governing insurance, and then we'll talk about 82.067, which is the provisions which govern the amendment of declaration. So let's get started. And I will say up front, some of these statutes are really comprehensive and detailed, and we could probably, spend 45 minutes talking about each one, specifically with insurance for sure, and probably 82.067. So I want to be upfront and say we're not going to cover every single detail of these statutes, but we are going to cover the highlights. And if you've still got questions, I'll answer them. But we won't cover every detail, and I just want to give you that caveat. All right. So 82.114 of the Uniform Condominium Act is an interesting provision. It does a couple of things. The first thing it does is it talks about what records the association is required to keep. You can kind of see them listed there, but essentially the association is required to keep detailed financial records that comply with generally accepted accounting principles and that are sufficient to be able to produce the information that are required by resale certificates. You're also required to keep plans and specifications, basically construction drawings of the condominium that were used if the condominium was created on or after January 1st of 1994, okay? You're required to keep copies of your condominium information statement, which is the disclosure statement that developers give when they are selling units to the original owner. The name and address of each unit owner, voting records, proxies, correspondence relating to any amendment to the declaration, as well as meetings of the Condominium Association's members and board of directors. It doesn't specifically say this, but I would tell you, you also need to keep copies of any written consents executed by boards in lieu of approving actions at a board meeting. You need to keep those as well. So that's what you're required to keep. Now, there are a couple of additional things, but they're not part of 82.114. They really kind of fall under 82.1141. Really, since the inception of the Uniform Condominium Act, which was enacted in 19 or took effect in 1994, this has kind of been the standard for what documents you're required to keep. And they also had a provision in 82.114 that talked about unit owners' rights to inspect documents. And what it used to say was that unit owners were entitled to inspect books and records, all books and records of the condominium association upon request, is what it said. And it was very comprehensive in that there were no exceptions from what documents unit owners were not entitled to see. And it was silent on how soon you had to make them available. It was silent on whether or not the association was able to charge for production of records. It just said they must be made reasonably available to unit owners. And so it was all records of the association to be made reasonably available. In 2011, Chapter 209 of the Texas Property Code, which governs subdivision developments, not condominium developments, was modified to include what I would call a light version of the Open Records Act that established some pretty detailed procedures for requesting records of a homeowners association and the requirements of the association to produce those records, as well as setting forth standards for charging owners for making copies. But that applied only to subdivision associations, not to condominiums. Well, in 2021, just this last legislative session, the Uniform Condominium Act was modified or amended to include not an exact version, but a nearly identical version as to what was incorporated into Chapter 209 in 2011. So it's not 100% identical, but it's almost identical. The same things that were put into Section 209.005 of the Texas Property Code have largely been now incorporated into the Uniform Condominium Act, and that is 82.1141. So let's move on to that statute. Oh, I forgot one thing. So in 82.114, which talks about the documents you're required to keep, it also does say that condominium associations are required to perform an annual audit. Those audit reports are records of the association that must be made available to unit owners upon request. So 82.1141, first thing it does is it requires condominium associations to adopt a records retention policy. I'm sorry, all condominiums of at least 8 units. So let's say that all condos composed of at least 8 units must now, as of September 1 of 2021, adopt a records retention policy. And that policy requires certain categories of documents to be retained by the condominium association for certain periods of time. You'll see them listed here and bullet pointed, both the category as well as the amount of time. So you'll see here, all of the governing documents must be retained permanently. All your financial books and records must be maintained for at least 7 years. Account records regarding current owners must be retained for at least 5 years. All contracts entered into by the condominium association with a term of 1 year or more must be retained for at least 4 years following the expiration of the contract term. Minutes must be retained at least 7 years. I would recommend you keep those permanently, but by statute, at least 7 years. And tax returns and audit records, at least 7 years. So that's the document retention policy that you are now required to adopt and record in the official public records of the county in which the condominium development is located. All right. In addition to that, it now makes clear that unit owners have a right to inspect and obtain copies of the condominium association books and records. And this is really what's been in Chapter 209 for the last 10 years, but we're going to see it now in the Uniform Condominium Act. And it sets forth the very specific procedure for owners to now request those documents, procedures for the production of those documents to unit owners, exceptions, which didn't exist before, but now there are some exceptions for when the association does not have to produce records. It also has provisions for how much you can charge, and it creates a new statutory remedy if the association fails to timely produce records. It now allows unit owners to bring a lawsuit to enforce these rights under this new section. So let's start with the procedures for unit owners to request documents. So the way it starts is that a unit owner absolutely has a right to inspect and get copies of the record, and they must do so by submitting a written request for information. That written request must describe the categories of records being requested with sufficient amount of detail, and it must contain an election by the unit owner to either one, inspect those books and records, not actually to get copies, but be able to have access to the records to inspect them, or to have the association forward copies of the requested books and records without any advanced inspection. Okay, so there's two processes. You can inspect the documents, or you can just request copies of the document. Now, we'll get into this in just a second, but if you request to inspect the books and records and following that inspection, you want to be able to obtain copies of some or all of the records that you inspected, you can do so at that time. You can request it at the inspection, but on the front end, you either want to inspect records or you want to obtain copies without an inspection. All right. Now, prior to 2021, there was no exception to what documents the association had to produce to unit owners. Now there are. 82.114 makes clear that any records of the association or pertaining to the association that are in the care, custody, control of the association's attorney are not subject to an owner's right of inspection unless the attorney has the only copy, meaning you cannot hide documents from your unit owner by giving the attorney all copies of it and not retaining any for yourself. If you give documents that would not be considered attorney-client privileged documents and they're in the possession of the attorney, and that's the only copy, you're going to have to produce them anyway. There are also exceptions involving an individual unit owner's history or violation of the dedicatory instruments. So covenant violation history, rule violation history, and individual unit owner's personal financial information, including records of payment or non-payment, a unit owner's contact information or address, and information related to an employee of the association, including personnel files. Now, the statute does say you are required to produce those categories of documents if the individual unit owner whose personal financial information or violation history is at issue, if they consent to it or a court orders it, you will then be required to produce it. Other than that, the statute says you're not required to produce it. Now, it's an interesting choice of words. It doesn't say you can't produce it. It says you're not required to produce it. What's clear about the statute, and I actually dealt with this issue last week with a client, is that this document is not a shield or a privacy shield for your unit owners. It does not create a privacy issue for unit owners in that a unit owner can say, well, you produce records involving my personal financial information without my written request. This is not about a shield of private information. It is about imposing an obligation upon the association to produce records. So what it's basically saying is that the association is not required to produce these categories of records, but if the unit owner who is issue, whose information it is, or the court orders it, then the association is required to produce it. But if an owner who's not the requesting owner, whose information it is, doesn't consent to it, you can still produce it, but I would generally recommend not doing so because you want to be consistent about it. But I just wanted to be clear, it's not an absolute bar from producing this information. it's really more of an exception from the obligation that you. All right, so we're going to kind of take this in chronological order here. So let's assume that a unit owner has requested the information in writing. The association must now, if it's an inspection of records, make those records available for inspection within 10 business days from the date of the request. And within that same 10 business days, you must send a written notice to the owner telling the owner, here's the date and time where you can come, and the location where you can come and inspect those records. Or if you're unable to make the records available for inspection within that 10 business day period, then you still must send a letter to them within the 10 business day period telling them we can't make it available within 10 business days. Here is the date by which they will be made available. And that date can be sometime after the 10-day period, but it cannot be further out than 15 business days from the date that you send this particular letter. So kind of taking it to its furthest extreme, if you receive a written request for inspection of records, you can wait till the 10th business day to send a letter to the owner. So that would be basically 2 weeks. And you can tell the owner at that time, we'll make the records available to you within 15 business days from the date of the notice that you're sending. So that will give you an additional 15 business days, which is 3 weeks. So basically the furthest out you can go on inspection is 5 weeks. First 10 business days and the following 15 business days. All right, let's see. Now, if they're at the inspection and they're reviewing documents, going through piles of documents, if they want to then have copies of those documents, the unit owner must identify which records they want. They can maybe put them in a certain pile, set a pile aside, maybe they take Post-it and flags it, and then they just need to notify the association, I want copies of this particular document. I want to look at them all. I'll decide which ones I really want. Once they looked at them, they can say, I want copies of this. The association then is responsible for making the copies and delivering those to the requesting owner within 10 business days from the date of inspection. Okay, so if they want it at the inspection, you have 2 weeks basically to make the copies and deliver them. If an owner instead requests copies of documents without an advanced inspection, then the association's responsibility is basically the same as the inspection, which is to produce the written or the requested documents within 10 business days of the written request. Or if you're unable to do so, you can send a letter within the 10 business day period notifying the owner, we're not going to be able to produce the documents within the 10 business days, but they will be produced by, and you have to specify the date they'll be produced by, and that date cannot be further out than 15 business days from the date of this written response back to the owner. So again, you've got the furthest out, you've got a 5-week period. The association has the ability to produce books and records. It's their election. They can produce them in hard copy, electronic form, or any other format that's reasonably available to the association. The association gets to make that choice, not the requesting unit. All right. Now, the next thing that the statute makes clear is that an association can charge a requesting unit owner for making the production or producing these records, basically compiling the information and producing them, but only if the association adopts a records production and copying policy that sets forth all of the different costs that the association is going to charge to produce these records. And there are caps. Essentially, the Condominium Association can charge no more than a governmental agency can charge who is responding to an open records request for production of records. It's in a Texas Administrative Code, and it sets forth the maximum amounts that you can charge, depending on whether it's a digital or electronic file, or it's what kind of medium it's saved onto, or if it's a copy of a piece of paper. You're also allowed to charge some labor expense and some hourly rates, but that's all specified by the Texas Administrative Code. What we generally recommend is that you adopt a records production and copying policy that sets forth that you're going to charge the maximum amounts allowed under the Texas Administrative Code as it currently exists, and that it should be considered automatically amended if that administrative code provision ever is amended to allow for greater amounts. But you need to have that. If you do not adopt a records production and copying charge policy and report it in the official public records of the local county in which the development is located, the association is still required to produce the documents, but the association cannot charge for them. So you definitely want to get that adopted and record it. Now, there are also, and I don't cover it in here, but there are also, you have the right to require unit owners to pay for the cost of producing records in advance. What you generally have to do is you have to give them an estimate. They have to pay it. After you produce the records, then you have to do a true up where you actually determine how much the actual production copy charge policy or the production costs are. Then you provide an invoice to the unit owner. If the unit owner has overpaid, you have to remit the difference back to the unit owner. If the unit owner has underpaid, the unit owner is required within 30 days to pay the association the difference. You can also require, if you put it in your policy, you can require as a prerequisite to owners doing that they actually have to pay the amount. And if they fail to pay the estimate amount, then you do not have to produce the records until they do. So something else to think and consider about putting in your records production and copy charge policy. All right, now to the remedy. So 82.114 now says if an association fails to timely produce records that have been requested, the unit owner can file a lawsuit in a justice court, but the unit owner, before they file the lawsuit, must send a second letter to the association telling the association, if you don't produce all of the documents I requested, I'm going to file a lawsuit to enforce my rights, and that letter must be sent at least 10 business days before the filing of the lawsuit. So you're going to get a warning. If you don't respond to a written request for production of records, you'll at least get one warning before the lawsuit. If you get that warning letter that says, hey, I'm going to file a lawsuit if you do not produce the records, then you definitely want to look at it to make sure you've produced all the documents that you believe you are obligated to produce. If you haven't produced everything, or if you haven't timely done it, the unit owner can then file a lawsuit in the justice court. And the statute provides for two remedies: a judgment ordering the association to release or allow the releasing of those requested books and records, and or a judgment against the association for cost of court and attorney's fees incurred in connection with the lawsuit. So that's the remedy. And it is going to be filed in justice court. All right. So let's talk about insurance. In section 82.111, and as all of these provisions are provisions that apply equally to associations that were created prior to 1994, as well as condominium associations created on or after January 1st of 1994. And that's certainly true for the insurance provision. So 82.111 is the provision that governs all of the insurance, and that includes issues of what insurance coverages are required by condominium associations. Issues such as the submission of liability claim and property damage claim. Issues about application of deductibles. Those are all addressed by section 82.111. And so I want to start with the coverage requirements under section 82.111. First off, it requires all condominium associations to carry commercial general liability insurance in an amount to be determined by the board, but it cannot be less than any amounts required by the declaration. So if the declaration requires a certain amount of insurance to be carried, a liability insurance, then that's the minimum amount. Otherwise, it's completely within the discretion of the board. The liability insurance is required to include medical payment insurance, and it's required to cover all occurrences that are commonly insured against, including death, bodily injury, property damage. Okay, so that is the liability insurance coverage requirement. Secondarily, it requires property insurance. Now, the property insurance is insurance that's going to cover all risks of direct physical loss commonly insured against, including fire and extended coverages. Okay. Now, the other part that's a little interesting is that the threshold is it must be at least 80% of the replacement cost for the actual cash value of the insured property. Now, what does that mean? Well, replacement cost means the amount of money in today's dollars that it would take to completely rebuild the condominium. Okay, so whatever that cost is, that's what is replacement cost. Actual cash value is replacement cost. Oh shoot, what's the term? Dang it, that's escaping me. When it's old and it's dang it, y'all aren't speaking live, somebody can jar my memory. So it's the replacement cost less the oh dang it, and I don't have the property code in front of me. I'll come back, just bear with me for a second. It's the depreciated cost, sorry, less depreciation, sorry about that. All right, so like for example, let's say you have a 20-year roof, you have a bunch of hail damage, it's year 18, the claims adjuster comes in and says, okay, it's a total loss. The actual cash value of the roof, however, is it would be $500,000 to replace it under today's terms, but you have a actual cash value, and since it's a 20-year roof and it's in year 18, we're going to subtract 90% of it. Okay, so then it turns out you get the replacement cost, which is $500,000 less 90% of that, and that's how much your coverage is. So actual cash value generally is going to mean that you're not getting 100% replacement cost. So if you do 80% of replacement costs, and let's go back to that same scenario, you've got total loss on the roof, the replacement cost is $500,000, but you only insured it at 80% of replacement cost. Well, then they're going to issue a check for $400,000, and you are essentially self-insuring that 20% that you didn't cover. If you were to do the minimum threshold, which is 80% of actual cash value, then they're going to take what's the replacement cost, less depreciation, and then they're going to apply, they're going to subtract 20% off of that to account for the 80%. Generally speaking, we always recommend, and I think most insurance brokers will recommend that you do 100% replacement cost because of that self-insuring insurance part. But I will also tell you that if you want your condominium to qualify for FHA loan guarantee program, FHA's underwriting requirements require 100% replacement cost insurance, or you won't qualify. So another good reason to do that. In addition to insuring all of the common elements, which is what 82.11 requires, it goes on to say that if there are horizontal boundaries between units, the association must ensure not only the general common elements, but it must also ensure the units. Now, what does horizontal boundaries between units mean? It means that if you have a unit here and a unit above it, there's a horizontal boundary between the two units. So essentially, if any part of the development has one unit that is above another unit, you've got horizontal boundaries, and now you're going to be required to ensure not only the common elements, but also you're going to be required to insure the units as well, but not necessarily betterments. So the statute says you're not required to insure betterments unless your declaration requires it. So what are betterments? Well, betterments are any improvements or upgrades made to a unit after it's sold by the developer. So I've been involved in situations where you have a high-rise condominium and the developer would sell each unit as basically sort of an empty box. You'd walk, from the common element hallway into the unit and there were no demising walls. It's literally just a cement foundation and glass, and you have a big open space, and you bought it like that, and the individual unit owners would have to come in and put in the demising walls, the cabinets, the plumbing or the toilets, the sink, that sort of stuff. If that's the case, then everything outside of the wall separating the hallway from the unit is going to be considered a betterment. In which case you probably want the declaration to insure betterments, or you want to make sure that your unit owners are aware of that. But it could be where the developer built it out, all the demising walls, everything, cabinets, countertops, sinks, that sort of stuff. But over time, unit owners have come in and replaced countertops. Maybe it was Formica. Now they've replaced it with granite or marble. Well, those upgraded countertops would be considered betterments, and they would not be covered by the association's property insurance policy unless the declaration requires coverage of betterment. In addition to liability insurance and property insurance, 82.111 also says the association must carry any insurance coverage required by the declaration, and that they can cover any additional insurance that the board considers appropriate to protect the condominium, the association, or the unit owners. So that's kind of optional insurance, and it gives the authority of the board. If they think it's appropriate, they can cover it. All right. There are some additional requirements for a property insurance policy. And it becomes really important because if you think about it, in a condominium, unit owners own their units, but they also own the common elements. I mean, the common elements are basically portions of the building that are owned by all of the unit owners. So the association is insuring common element property that is owned by all of the unit owners, who are technically the owners of the common elements. So we want to ensure that when the association is taking out that policy, that it's also protecting the actual owners of the common element, the unit owners. So what you'll see in section 82.111 is that each owner is considered an insured person under the policy with respect to liability arising out of their ownership in the common elements or their membership in the association. It also requires the insurance carrier to waive any rights of subrogation against unit owners. So, not everybody knows what subrogation is, but essentially subrogation is a right of an insurance carrier that if they pay out money on a claim and the damage that the claim is related to was caused by somebody other than the insured party, the insurance carrier can then sue that party to recoup the money they paid out on the claim. I'll give you a quick example. Let's say that, and I'll do it in a different context, but let's just say you've got some kids whose parents gave them some fireworks. They go out into the middle of the street, they shoot off some bottle rockets. One of the bottle rockets lands on a home and burns it to the ground. The homeowner might submit the claim to their homeowner's policy. That carrier may come back and rebuild the home that burned down, but because the damage to the home was caused by these kids down the street, might turn around and sue the family whose kids shot off the bottle rocket to recoup the amount of money they spent rebuilding the house on behalf of their insured. So that's a subrogation. In this context, what it's saying is that the condominium association's policy or the carrier for that policy cannot turn around and sue a unit owner to recoup their losses for monies that were paid out to the association to cover damage to the property that the unit owner owns. Okay, so there is a waiver, has to waive this right of subrogation so that unit owners aren't getting sued by the association's policy holder. In addition, you have to, it cannot allow for, or must, you can't have the carrier terminating policies because of some act or omission caused by the unit owner. You have to have at least a 30-day notice of cancellation so that the association has time to get a new policy if the carrier cancels it. All right. And I know this is going to be a question that's going to come up later, which is, what if we've got horizontal boundaries, meaning the association is going to be insuring the unit, and let's say the unit owner is carrying what's called an H06 policy. And H06 policies are the type of homeowners policies that unit owners carry, and it also covers the unit. And so now we've got overlapping insurance coverage both on the association's policy and the unit owner's policy. Whose policy is primary? Well, by statute, the association's policy is going to always be primary, meaning you submit the claim on the association's policy, and to the extent there's any portion of the damage that's not covered by the association's policy, then that would then be covered by the unit owner's policy. I'll give you an example. Let's assume we've got horizontal boundaries. We've got a unit that was originally built out with Formica countertops. And the declaration does not require coverage of betterment. So those unit owner, and at some point prior to the occurrence, replace the countertops with granite. When there's a property damage claim, the association's policy is going to come in and adjust the claim, meaning they're going to set the amount of damages to be covered at what it would cost to replace that countertop with a Formica countertop. That's going to be the extent of the coverage because betterments are not covered. So the association would cover that. If there's overlapping insurance by the unit owner, then the unit owner, or if there's the unit owner's policy, then would cover the difference in costs for there to be replacement with a granite countertop. So the amount of money allocated will be enough money to replace it with Formica. Then the unit owner or their carrier would chip in the additional money necessary to then repair it with a granite countertop. That's how that would work. Now, there's going to be a deductible amount. And this is really a change to the Uniform Condominium Act. I want to say it occurred in either 2015 or 2017, but it was relatively recently. That changed how deductibles are applied and also the submission of claims. And it's pretty interesting and can be very helpful. The first thing it says is that the association no longer has a strict obligation to submit a claim on the property damage or property insurance policy anytime there's damage to a unit or common element. Now what it says is if the damage to the unit or common element, if it's covered by the insurance policy, but it is less than the deductible amount, the condominium association is no longer required to submit a claim. And that makes good common sense because if it's less than the deductible amount, the carrier is not going to be covering it with any amount of money anyway. That claim now adds to the negative claims history, which might have an effect on premiums in subsequent years. So no longer going to be required to submit a claim. In the event that the association is not required to submit a claim, the statute goes on to say that the party responsible for the repair in absence of insurance coverage must pay. Meaning we're not going to look to what the insurance coverage is. We're going to look to see who caused the damage. So assuming we've got a condominium, we've got a unit on the third floor whose toilet overruns and floods the third floor unit. Water trickles down into the units below it, causing damage to sheetrock and some other stuff within the units below that third floor unit. If the amount of the damage was above the deductible amount, then you would submit that to the association's carrier. However, if the amounts are not above that threshold, then the person responsible is the person who caused it. That would be the owner of the unit on the third floor. So that's how that would work. Now, if the cost to repair is more than deductible, then Section 82.11 now has some provisions about, well, who's responsible for the deductible? essentially what it says is that the deductible shall be allocated pursuant to the association's dedicatory instruments. Primarily what we'd be looking at here is the declaration. So if the declaration says the unit owner who caused the damage is the one who's responsible for the deductible, or the unit owners whose units are the ones who are going to receive insurance proceeds are responsible, it could say that. But if the declaration or other dedicatory instruments are silent on how the deductible is to be applied, the statute says that the board can adopt a resolution governing the application of the deductible. Meaning, you could do the same thing as you could say whoever's responsible pays the deductible, or you could say whoever's going to receive the insurance benefits for their unit is responsible for the deductible. If the dedicatory instruments are silent and the board has not adopted any resolution regarding this, then the statute says by default it's going to be treated as a common expense, meaning it just comes out of the association's operating account. Now, there is another provision that sort of trumps this, and it basically says if the damage is due in whole or in part to an act or omission of a unit owner or their guest and invitee, that would include the tenant, then the association may assess the deductible and any expense that would be in excess of the insurance proceeds against the owner of that unit. Okay, so when we talk about the deductible application and how it gets applied, that's going to be kind of in the event of a no fault or no cause. So let's say it's a hailstorm, or it's a fire, or Weather Storm Uri, which caused fire suppression systems to explode. That's where you're going to be looking at the deductible application provision. But if the damage was caused by a tenant who set fire to a couch in the middle of the unit, then we're going to apply the deductible against the owner of that unit because the damage was caused in whole or in part by the unit or their guest or invitee. All right. So that's kind of, and I don't talk about it, I'm just going to stop there for a second. There are some other provisions of this. Again, this is a very comprehensive statute on the insurance. For instance, there's some provisions about who gets to submit the claim on the insurance property policy. That's going to be the association. There's some provisions on the payout of those proceeds, which says all insurance proceeds must be paid to the association or a third-party insurance trustee appointed by the association, but they cannot be paid directly to unit owners. The insurance proceeds must be used to repair or rebuild the damaged common elements in units, and they cannot be dispersed to the unit owners unless there are excess proceeds after everything has been repaired. It also says that any part of the building that was insured by the insurance policy must be promptly repaired unless, and there's a few exceptions to this, but predominantly you must repair it if you're able to. If there is not enough insurance proceeds to pay for the repair, then the association must pay for it out of their operating account. And if there's not enough proceeds there, the association must issue a special assessment to cover any deficiencies in the amount of insurance necessary to complete the repairs. So, that gets into, if you're going to do anything less than 100% replacement cost insurance, you're going to have to self-insure those repair costs that are going to be there because it's not 100% replacement insurance. So something to think about. All right. So that's kind of the insurance part, but we can't cover it all in detail in order to stick within our 45-minute time. Now, I want to talk about amendment of the declaration, and in particular, I want to talk about what I call the dirty little secret here. But as a general rule, in order to amend the declaration, it must be approved by the vote or the agreement of unit owners representing at least 67% of the votes in the condominium association. Okay, that's the general rule, unless the declaration provides for a higher amount. So a declaration could require 100% or 80% or 90%, but it cannot require 60%. So it's 67% or any higher amount. An amendment to the declaration can be adopted one of three ways: by a written ballot, at a meeting of the members of the association after written notice has been given to everybody, and by any other method permitted by the declaration. Okay, so that written ballot that I named first, I'm not saying a written ballot submitted at a meeting. I'm talking about a written ballot that would be mailed to everybody. There's also a statute of limitations if anybody wants to challenge the validity of amendment. It's 1 year. And to be effective, the amendment must be recorded in each county in which a portion of the condominium development is located. Now, there are some exceptions to this general rule, some special rules. So for instance, and this is what I like to call the dirty little secret, which is this. The Uniform Condominium Act says that certain types of amendment must be approved by 100% of the unit owners and nothing less. And that would be in order to increase special declarant rights, to increase the number of units, change the boundary of a unit, alter or destroy a unit or limited common element, change a unit's allocated interest, or, and this is the big one, change the use restrictions on a unit. Now, why do I call it the dirty little secret? Well, I think a lot of people ignore this. I think a lot of people will amend the use restrictions on in their declaration just by a 67% vote. So for example, what's a use restriction? Let's say that you don't have any short-term rental restrictions and you want to create some new short-term rental restrictions. Well, short-term rental restrictions is a use restriction on a unit. And according to this, in order to do that, you would have to amend the declaration by a 100% approval requirement. We see this ignored all the time for whatever reason. I will tell you that there is no Texas appellate case looking at this particular provision and this 100% voting requirement on a use restriction. But I know several lawyers here in Texas. I've been doing this for 24 years. And there's a couple of lawyers that do nothing but sue HOAs. That's their entire practice. All they do is sue HOAs. I know them very well because I represent HOAs. And I've talked to a couple of them because I've never had to litigate this particular issue, and there's no appellate cases on it. And I've asked them, have they ever challenged an amendment on the basis of this 100% approval rule? And I've had a couple of them tell me multiple times they've done this, and in every instance, the trial court rules that the amendment is invalid. Now, the condominium association could then appeal that rule and see if an appellate court would affirm it or reverse it. But to date, none of them have done that, not one. And I suspect it's because the lawyers representing the condominium association don't want to run the risk of getting an adverse ruling, because once we get an appellate opinion on this, the ability, everybody's going to know the secret's out there and you cannot amend it with anything less than 100% vote. So I honestly think that there is a concerted effort to not get an adverse ruling at the Court of Appeals. So the trial courts are invalidating amendments on this basis, and it's not getting appealed up to the appellate court because nobody wants to see an adverse ruling that lets the cat out of the bag. But I'm telling you this so you're aware of it. In addition, there's a couple of other things. Basically, an amendment cannot increase or otherwise modify any of the obligations imposed on a condominium or by the condominium declaration on a declarant unless the declarant consents to it. And there is a provision that allows the board or the declarant, so long as the declarant still owns at least one unit that's never been occupied, to amend the condominium declaration without any approval of owners, but for the limited purpose of meeting the underwriting requirements of Fannie Mae, Freddie Mac, FHA, or VA. So you don't have to go to the unit owners as long as your amendment is for the limited purpose of having your documents comply with the underwriting requirements of those organizations. All right, I got it done, I think, in the 45 minutes. It's a lot. It's actually a lot of information. We could probably spend 3 hours talking about those if we were to do so in detail, but hopefully you kind of get the highlights of those statutes.
Yes, thank you so much. There are a lot of questions that have come in, Greg, so I hope you're ready.
I think I'm ready, so let's
Well,
look at those.
There are some pre-questions that we had, and I'm going to ask those. We have about 4 pre-questions, and there's a couple of scenarios. So I will ask those to you. And once we're done with those, hopefully we'll have time to ask the other questions that have come in. So the first question, I mean, this is kind of a lengthy question. And so if I think I kind of already sent it to you, so you can at
Yeah,
least
I
view it.
got it.
So and actually I kind of got a little bit of wording corrected. So I'll go ahead and ask it, and I'll let you address it.
Okay.
Great. Is the HOA policy primary if there are stacked units, horizontal boundaries, and the repairs are more than the named peril, or AOP deductible for damages from long-term wear and tear damage? For example, there is a slow water leak behind a shower head, or the shower pan and the water causes damages and mold in that unit and the unit below.
Well, what I will say is, because the question says, is the HOA's policy primary? The HOA's policy is primary, period, in all scenarios, regardless of the fact pattern there. The Uniform Condominium Act says the HOA's policy is always going to be primary. Now, if you've got horizontal boundaries where you're covering units, and you've got an actual cash value policy where there's going to be a depreciable amount, the amount of the coverage is certainly going to be less than the actual repair cost, meaning there's going to be some amount that's not covered by the primary policy. And that's where the H06 policy is likely to come into play, is to cover that differential.
Okay.
And I think that's what they're asking, but
Right.
the statute provides the association's policy is always primary to the H06, the unit owner's H06 policy.
So there's part 2 to that. There's another one, similar question, but the only part that's different is the deductible for water damage to only one unit. So no other units or common area is damaged. So they're asking kind of the same question.
Yeah, and I'm not sure that they're really intending to ask about which policy is primary, because you've got a couple of different issues. I mean, there's the statute says the association's policy is always going to be primary, which means you're going to exhaust it first, right? And then you'll look for any excess coverage under the unit owner's H06 policy to the extent there is any. But the deductible is an entirely different question, right? So, the assessment of a deductible is entirely unrelated to whether the the Condominium Association's policy is primary. I'm not sure, without maybe a little bit more clarification on that particular question, exactly how to answer it, because I'm not sure if they're trying to get into the deductible amount there, but maybe if they're online, they can chime in after we get through these questions and maybe give us a little bit more clarification.
Yes.
Let's go to number 3.
Okay. Number 3, and we'll circle back to this. I'll be watching the questions to see if there's any follow-up to that. So there's a scenario on question 3. So I'll read the scenario and then I'll ask the question. So the remediation of mold in several high-rise units was caused from a long-term wear and tear water leak and would be more than the water deductible of $25,000. However, there is a sublimit on mold coverage in the HOA's policy of $5,000 and maybe no coverage for the long-term wear and tear damage. Do we file a claim on the HOA's policy with little or no coverage?
Well, if the amount of the damage is above on the water deductible is above $25,000, you're required. The only time that you can elect not to submit the claim is if the damage is below the deductible amount. And there can be cases where, depending on your coverage, there might be some coverage, where it's above the deductible and some separate coverages where it's not. So you may end up having to submit a limited claim, but you have a duty to submit a claim if the damage amount is above the deductible. That's not a discretionary decision that you can make.
Okay, thank you so much. Here's a second scenario. When the HOA's policy is primary, it normally repairs back to original construction. Is that the date of the building's certificate of occupancy or the date of the condo HOA association was recorded?
So I think what they're trying to ask is where you have coverage that doesn't include betterments, and you're going to estimate the cost back to what it was originally constructed at, right? It's not really kind of the date. It's really like what was constructed there. It's going to be at the time that the units were sold. So so it's not when the declaration, it's really more about what was constructed and what existed at the time that the units were sold to their initial purchasers. Because a betterment is any improvement made by a unit owner. So this would have been things that were constructed. So it's not really a date specific. It could be after the certificate of occupancy. It's just what was the condition when they were sold. Unless there's something I'm not aware of in a policy, but I think this makes me think this fact pattern is they're wanting to figure out what would be considered a betterment and how do you go about figuring out, what was a betterment versus what was original construction. And you may have to go back and look at your construction plans. You might have to see if there's anybody in the building who was an original owner. You might have to look at a bunch of different ways. In absence of anything else, you might look around and say, okay, we've got, let's just say it's 25 units. 70% of them have Formica countertops. Well, most people upgrade countertops. They don't downgrade countertops. So I would say, at a minimum level, that was probably the standard was Formica countertops, and anybody who has something better than that probably upgraded it. But that was probably the standard because you've got so many people and nobody's going to rip out granite and replace it with Formica. So it may just be something you have to look at and try to determine. And ultimately, you might have to negotiate that with the claims adjuster in lieu of any information being able to establish it.
Understood. Thank you. I think this one is going to be, I think you touched on this, but I think I just wanted clarification. Says if a unit owner tampers with the fire sprinkler in their unit and causes a flood affecting adjacent units and common elements, you stated that the association insurer cannot pursue reimbursement from the owner. They just want to make sure they understood you correctly. And there's a part that says, would this be a case of the association assessing the deductible and excess expenses?
Yes, that's right. It would be. So that would fall in the act or omission that caused the damage. But the association's non-subrogation part would prevent the insurance carrier from going after the unit owner for that damage. And that's assuming that the damage was above the deductible amount and you submitted a claim. If it was below the deductible amount, however, then you would treat it as if there was no insurance, meaning the association would just go after the unit owner for the full amount of the damages.
Okay. All right. It looks like there are a couple of, okay, I'll do this one. So LLCs and other legal entities who may own a unit, what proof of ownership are they required to produce? Must they disclose who is the legal manager representing the LLC or legal entity?
Well, I would say that you would want them to have a proxy signed by somebody who, purports, so if it's an LLC, you would want the managing member of the LLC to sign a proxy appointing somebody, a representative, to vote on their behalf at the owner meeting, right? You could do I'm assuming this is what we're talking about, right? Proof of ownership for me. Oh, you're talking about if they were required to produce documents? You could do the same thing. You could have somebody who just signs as a managing member of the LLC. If we're talking about a written request for information, yeah. And I don't know what else proof. I mean, if they represent that they're the person, there's not really like an affidavit or anything. I would take it on its face value. Generally, you're going to know, I think in a lot of cases, because if you're communicating with that unit. But I would look to, if you can find anything that's been recorded, a deed or something else where somebody has signed on its behalf. But generally speaking, if they've got something that says that they've been appointed or that they're signing the written request as a managing member of that LLC, I would take it on face value, frankly.
Okay. Looks like we have enough for maybe a couple more questions.
Yeah.
Because it's already 6. But what is the recourse for an association not meeting their minimum annual meeting requirement?
Meaning not getting a quorum, you just have to keep calling your meetings until you get a quorum. Because nonprofit corporation law requires you to conduct an annual meeting, and the remedy is if you don't call one and somebody demands it and you don't get it accomplished, they can file a lawsuit to have the court order you to do it. You got to have to do your annual meetings, and there's a number of strategies that will work to get people to show up. And so I would recommend they talk to the association's legal counsel, but there is a statutory requirement of the nonprofit corporation law to conduct an annual meeting, and failure to get a quorum is not a defense.
Excellent. And this will be the last question. Can boards make decisions in working sessions, and do they have to be approved in the board meetings?
The answer is, we typically think of working sessions as they're not really, I would say they're not meetings, but where you're doing information gathering, but you're not voting. If you're voting on something that should occur at a board meeting, but if you make a decision in a work session, so long as you put it on the next meeting agenda and you ratify it, I'm generally okay with that. But as a general rule, you want to approve things. Boards should be approving things either at a meeting in which a quorum's been established and it should appear on the meeting minutes, or it should be done by unanimous written consent outside of a meeting. That means limited to all the actions that can be approved outside of a meeting. There's four categories that can't be, but essentially you want to do it at a meeting in which a quorum's been established, and that's where you vote. If you want to talk about stuff at a work session, you want to agree to stuff at a work session, that's fine, but go ahead and put it on the meeting agenda and go ahead and ratify it at the next board meeting.
Excellent. Well, that's all the time we have for this evening. Greg, thank you so much. We definitely appreciate your time, and the presentation was excellent.
All right, take care, guys. Thank you.
Yes, everyone, thank you so much for attending our event. This session was recorded, and I will distribute it, the link out once it is available on our YouTube channel. We hope that you have a great evening, and we look forward to seeing you next time. Thank you so much.